whole or in part from those of the old contract. Guidance on when this will be the case was given in Rose and Henry Trickett, which is on the slide. And there are three main points made in that case relating to when such a statutory trial period will have to be in place. So termination during the trial period, essentially what those sections provide for is that where there is termination either by the employer or by the employee during the trial period, that termination will be, the employee will be treated as having been dismissed when the original contract came to an end, and for the same reason that that contract came to an end, so for reason of redundancy. If the employee gives notice of termination and the job was suitable, but the employee left it during the statutory trial period, then the employee will not be eligible or entitled to a statutory payment. And if the employer terminates, the employee will be entitled to statutory payment. So moving on. The next slide. So the key part of alternative job offers are the criteria of suitability and reasonableness. A job offer must be suitable, and the employee's refusal to accept that job must be unreasonable for that employee to lose a right, his or her right to a statutory payment. So again, the consequences are that the employee loses the right to statutory payment where a suitable alternative job offer is made and the employee unreasonably refuses that offer. It is particularly difficult to give you any sort of specific factor or guidance as to suitability and reasonableness, because they are generally questions of fact for a tribunal. So it will be very difficult to overturn a tribunal's decision on appeal. This is particularly so because the test is both an objective and a subjective one. So the tribunal will have to determine the question objectively, but it must have regard to the subjective circumstances of the specific employee in question, and will have to assess whether that job offer is suitable for a specific employee, so in relation to the specific employee concerned. And again, reasonableness and unreasonableness also depend on factors personal to the employee. However, the tribunal will err in law where it substitutes its own view of suitability to that of the employee, and that is Burden, Stoke-on-Trent. So again, it is difficult to extract general principles, but the cases there, so Day and Premier Grocery and Goodwin and Total Security illustrate, for instance, the fact that even a minor change in terms of employment may affect specific employees differently. So a minor change in terms of employment might be suitable and reasonable in respect of one employee, but not suitable and reasonable in respect of the other. So it is generally quite a factual question for the employment tribunal. So the criteria are interrelated. Generally, the practice is that a tribunal will determine if the job offered is suitable first and then address the question of reasonableness. However, that is not required by law, and the Commission for Healthcare case cited on the slides makes it clear that there is no requirement for suitability and reasonableness to be considered in isolation of each other. So a tribunal is entitled to consider them together. So again, although I did mention that it is difficult to extract specific factors applicable to a determination of suitability and reasonableness, a number of relevant factors are listed on the slides. So generally, job content and status is particularly important in this regard. So if the status of an employee changes significantly because of the new terms offered, then a tribunal might well find that that offer is not suitable and reasonable. Obviously, pay and benefits are relevant to determining whether the two jobs were similar or different, and whether the new job is suitable or not. Hours of work, workplace, job prospects, and the timing of the offer are all also relevant factors. So moving on. In terms of remedies, so eligibility for redundancy payments, the right for redundancy payment is set out in section 135 of the ERA, and the way to calculate the amount of redundancy payment owed is set out in section 162 of the ERA. Apologies, I omitted that specific reference from the slides. Employees only are eligible to a redundancy payment, and they must have a qualifying service of 2 years continued employment. Again, they must have been dismissed by reason of redundancy. However, there is one minor exception applicable to employees who have been laid off or put on short-time work, who are also eligible for statutory redundancy payment, so long as the procedure set out in section 148 and 149 of the ERA is meticulously followed. Going on. Final slide. So the available cause of action, the cause of action available to employees when there are issues pertaining to the payment of statutory pay, whether that is an absence of payment or payment of a wrong amount, is provided for by the Employment Rights Act, and employment tribunals have exclusive jurisdiction to consider issues pertaining to statutory redundancy payment. So that is set out in section 163 of the Employment Rights Act, and the time limit applicable to the claim is set out in section 164 of the Act. So generally the claim must be brought before the expiry of 6 months following from the relevant date, which is again set out in that section. However, there is a discretion to extend time if the tribunal considers it just and equitable that the employee should receive redundancy payment, having regard first to the reason why the employee failed to take any of the specified steps earlier, and also to all the other relevant circumstances in the case. Finally, moving on, obviously, and Nick touched on this earlier, so I won't dwell on it too long, so we can have 15 minutes of questions. But where a redundancy has been unreasonable, where there's an issue in terms of how the employee was selected for redundancy, pulled for redundancy, or an issue relating to consultation, a claim for unfair dismissal lies, that is provided for by section 98 of the Employment Rights Act. Of course, the time limit is 3 months, so not 6 months as it is in relation to redundancy payment. And a dismissal for redundancy generally might be unfair either because it is not by reason of redundancy, or because it is automatically unfair, or because the dismissal was unreasonable. And that's the end of my part of the presentation, so we can have a bit of time for questions.
Well, thank you both very much indeed. You've covered a huge amount of ground between you in remarkably little time. As you say, Margarita, we have got about 15 minutes left for questions before 4 o'clock. I think, unless I'm corrected by Ray, our admin support, who's behind the scenes been controlling the slides, I think probably the best way to take questions would be to invite anyone who wants to do so to type it into the chat bar. I don't think we have a function for people asking them in person. Perhaps while you do that, I've just been thinking about some of the sort of odder redundancy cases I've done myself over the years and sort of come up with a couple of points. I wonder whether perhaps I could ask Nick and Margarita to give their views on these. As it happens, I was doing a redundancy case last week, and my opponent indicated at the start of the hearing that he was going to run a contribution point, so suggesting that my client had contributed to her selection for redundancy. It was circumstances where there was a pool of candidates, a restructuring pool of candidates, and an interview, and they said that in the course of her interview she didn't demonstrate herself to be appointable, and he was suggesting that that amounted to contribution on her part. I'd never come across contribution being argued in a redundancy case before. As it turns out, he didn't actually make any submissions on it at the end, so I don't know what he was proposing to say, but it seemed to me a little bit unusual. Another case I did where the pool for selection included the manager who was responsible for giving scores against the selection matrix to the other candidates, the pool. So she had a sort of built-in incentive to score other people low so that she'd be more likely to get over the threshold and not be selected for redundancy, which again I thought was quite odd. And the other point was about not having notes of the other candidates where selection has been done by means of an interview. You've got a limited pool of candidates for a limited number of posts, and we only had the interview notes for my candidate, not for the others, not because the employer wouldn't give them to us, which I think is quite a common position, but because they said they'd lost them without any real explanation for that. So I just wondered if the two of you like to comment quickly on those, or it would take one or two each or both.
There's a question. There is a question actually. Griselda Kelman has asked, if someone is in a unique role, can you offer them alternative employment within the business during the consultation period? So it sounds like that bad news for that person in terms of their job, if it's a unique role and it's just that one which is going, but certainly the answer would be very much yes. You should, as an employer, be looking to try and find your displaced employees alternative employment, and there's no rules at all as to when you can start offering it. So if it's looking likely that that job is going, of course, the way you would phrase that to the employee, you wouldn't want to give them the impression that the whole thing is done and dusted and decided. But nevertheless, if the reality is that that post is seriously at risk and is likely to be deleted for whatever reason, then quite clearly, to be fair to the person, you would start saying, well, look, if it turns out that your job is, in fact, not just at risk, but going, these are options. Would you be interested in any of those? And the sooner you do that, the better. And something else, which certainly employers, advisors would want to consider, is that the voluntary redundancy exercise doesn't sort of stop at any point really prior to, I would say, to dismissal. Because the benefit of getting people signed up on to voluntary redundancy, obviously for them the benefit is they tend to get a bit more money because there'll be a sweetener to try and tempt people to take voluntary redundancy. But from the point of view of the employer, then it has the attraction that they'll sign a compromise agreement if it's a voluntary redundancy, and a compromise agreement means no possibility of a claim. So the more people you get signed up on compromise agreements, the better. I have come across some organisations like Krona who apparently advise that basically once the consultation process starts, you can no longer offer voluntary redundancy. And that's in fact not the case. You can offer it all the way through. And it's a good idea because it means, as I say, people will be tempted, hopefully, into signing compromise agreements in return for getting a bit more money in their redundancy final pay package. So I don't know, Griselda, if that answers your question. I would, oh, there's a load of them now. God almighty, look at this.
Shall I read this one? Is there any legal protection for an employee whereby the employer never resupplied her with a copy of the contract? They're now in the process of offering an alternative job following redundancy consultation, but the terms are significantly different from her current role, but the employer is claiming to have lost her contract. She worked for them for 14 years and has only an offer letter. Margarita, do you want to deal with that one?
Yes, well, so even where there isn't a contract of employment, it will be possible for the in case this contract of employment isn't found. But generally, the employment tribunal will be able to establish what the terms of the current employment are and compare those to the terms of the new employment. So I imagine if she has worked for 14 years, she will have a clear knowledge of what her job description was, what her pay structure was, what her benefits were, and that can be there can be evidence such as payslips or receipt of benefits, other types of letters from the employer, which can be relied on. Nick, I don't know if you want to add something to that.
Well, if the employee's lost her contract, obviously that's a bit of a blow. I mean, an employer has a statutory duty, of course, under Section 1 of the Employment Rights Act to provide them with a statement of their terms and conditions. And so you could request a copy of that statement, even if you haven't got a contract. Basically, it should be similar, if not identical, to the terms of the contract. So that would be one way of getting around that. But clearly, if a person is being displaced, then really, the alternative employment is alternative employment, and whether they want to take it or not is going to come down to, can they do it? Is it suitable for them at all? And are there any personal reasons why they'd prefer not to do that? And the fact that whatever their contract for the other job may not have said, I don't know how much bearing that necessarily will have on that. A couple other questions. I'll do the bottom one. Are there issues of estoppel relevant if there's an enhanced contractual redundancy scheme and the employee applies to the tribunal for a declaration that he or she has been unfairly dismissed? If that's what you're, that may be a reference to me saying that if there are issues, it tends not to be around unfair dismissal, but is there an entitlement to a redundancy payment? So, for example, is the person redundant? Alternatively, have they been offered suitable alternative employment, which of course cancels the need for a redundancy payment? Now, those are issues which crop up in redundancy cases, and they also crop up in relation to the contractual schemes quite often that employers have. If you bring a contractual payment scheme, then often the value of the ability to award compensation for breach of contract in the employment tribunal, as you may well know, is 25,000. And some of these contractual schemes are a lot more valuable than that. Now, there is an estoppel point. If you bring a contractual claim in the employment tribunal and it awards you 25,000, you can't then go to the High Court or County Court and get a top up. So there's an estoppel point there. But there isn't an estoppel point if you go to the employment tribunal and get a declaration that the person is entitled to a statutory redundancy payment, because it's a different claim to the breach of contract claim. It's simply a statutory right which you're asserting and which is being dealt with by the employment tribunal, and therefore there isn't, in my view, an estoppel where, in relation to the breach of contract claim, you can rely though on the findings of fact in the statutory redundancy payment claim in the employment tribunal to stuff them completely in relation to the breach of contract claim in the county or the High Court. So as long as you keep them separate, that's fine. What you can't do is claim breach of contract in two places. Then you'll be taken to have elected to use the cheaper, cost-free jurisdiction, and having got that advantage, you're not then entitled to go and sort of top up in the High Court or the County Court.
Thanks, Nick. That's very comprehensive. Can I just suggest, Margarita, if you don't mind having a go at the final one about the employee who's got stress and anxiety and ultimately depression, presumably because of the redundancy consultation? I think that's suggested. It's a question from Sinead McCracken.
I was just going to briefly address also we skipped one question about pooling a single employee, and that has a very sort of quick answer to it. So you can pool a single employee, but you have to be careful that the employee that you're pooling on his or herself, let's say, is not doing a job that is similar or interchangeable to a job that other employees are doing, because in that case, the employee might claim that those other employees should have been pooled with her. So yes, you can have a pool of one, and that's Capita Hartshead, the case reference. But again, just you have to be careful about what the nature of that job is and whether that job is really unique or whether it's interchangeable or similar to other jobs. Let me just have a read of the last one. So I guess the difficulty with absences there, which I sort of referred to briefly earlier, is there is a risk where the employee knew that the reason for those absences, which I say used in one of those matrix scoring documents that Nick mentioned. So if there is a certain amount of points given to employees for absences, and the employer knows that some of those absences were for reason of a disability, so for reason of depression, prior to the consultation, absences prior to the consultation period, then it would be inadvisable to rely on that, because depending on the circumstances of the case, the employee might have a case that he or she is being discriminated against on the basis of a disability. The situation is different if the absences arise during the consultation period, but I think the question related to diagnosis of depression prior to being put at risk of redundancy, so I understand those absences were in relation to that prior diagnosis. So in that case, I would yes, encourage an employer to take that into account, and encourage an employer to be very careful that they are not risking discriminating against that employee by reason of a disability.
Yeah, just on that, obviously, there's a number of issues. You would need to consider, of course, whether whatever they have been diagnosed with, depression or anything else, is a disability.
Of course. That is the first point.
And it may or may not be, obviously we don't know in this particular instance. If it is a disability, then it's absolutely right to say that the employer will, of course, therefore, if it's a disability and their absences are being boosted by their disability in terms of the number of days they're having off sick, then clearly the employer is going to have a duty to make reasonable adjustments to accommodate that disability, which may well mean discounting some or all of the disability-related sickness absence as part of the redundancy.
And just going back to the important point Nick raised that I overlooked in terms of whether the depression is actually a disability. So there is a string of case law looking at whether stress and anxiety at work are themselves disabilities. And generally, the general thrust of the case law is that there has to be some sort of clinical diagnosis of a condition that bolsters a claim that stress and anxiety related to work are disabilities in themselves, because stress and anxiety, if they are caused by workplace factors only and do not affect the employee outside of work, so if the employee is unable to point to how that stress or anxiety affects the employee's normal day-to-day activities outside of work, so in circumstances that are not related to employment, then there will be an extra hurdle in establishing that stress and anxiety is indeed a disability. However, if the employee manages to show that the stress and anxiety are pervasive and not strictly tied to circumstances at work, then the employment tribunal will be more bent towards finding that that does amount to disability under the Act. But there is a word of caution in the use of the word stress and anxiety in GP records, for instance, because that in itself might not be sufficient to establish disability. I can get the case reference for that. Well, my laptop is not cooperating.
I think you've summed it up quite neatly, Margarita. The key will be whether or not the individual's condition meets the definition under the Act, won't it? And as you say rightly, one of the components of that is an effect on day-to-day activities. So providing you can show that you can meet the requirement for it to be long-term, and of course to be a physical or mental impairment, then you will get home on the definition of disability. That's perfect timing. I make it 4:02. I think we were due to run for an hour, and I think we started at 3:01. So I don't think timing could have been any more precise than that. I don't see any more questions coming up. Do we? Oh, is there? I stand corrected. Well, I'm not in a hurry to go anywhere, so I'm happy to carry on if you both are. What have we got? What have we got?
When creating a pool, it's in the chat, so not the questions.
I think Margarita dealt with. Is that the pool of one? Hasn't Margarita?
The pool of one, yeah, I think I've dealt with that.
No, when creating a pool, is it best practice to look throughout the organisation for staff in similar same roles, or can the pool be made up of staff specifically in one department in similar roles?
Oh. You're right, I hadn't spotted that one.
That is definitely a different question.
Well, I'll let you two fight it out over who wants to have first shot at that.
I'll leave it to Nick while I read it properly.
Is it? There are no hard and fast rules as to what you can and can't do. What, from the point of view of devising the selection pool you have to do as an employer, is give careful consideration to who should be in it. So, you know, for example, if you have an organisation which has a whole series of departments maybe based in different places, I don't think you'd necessarily, if you had a diminishing need of someone in a particular department in one place, you need to, you know, look around across the whole organisation. You may want to for other reasons, but I don't think there's absolutely any obligations to, and vice versa. What there is an obligation to do is just to make sure you've acted fairly and you've looked carefully across your workforce to see, you know, are there jobs really that should be put together that this person and other people could do, you know, who should therefore be considered as part of the redundancy exercise if you've got a diminished need for those people to carry out that particular type of work. So I don't think there is a clear answer you can give to those sorts of questions other than to say you've got to think about it and make sure you're fair to people. Yep.
Excellent. Thank you very much indeed, both of you, and of course to Ray, who, as I say, has been controlling things from behind the scenes. In the absence, I can't see any other questions coming up either in the chat bar or on the Q&A function, so I think we'll leave it there. But thank you very much indeed, Nick and Margarita, for those very interesting presentations covering a huge range of material, giving really an indication of just what a complex area of law this is. And of course, very timely to have a refresher now, because as you said at the outset, Nick, I'm sure we're going to be seeing a lot more of them in the future.
Sadly, that's true.
Indeed. Thanks very much.
Okay,
Goodbye. I hope you've enjoyed it. I hope you found it informative. Thanks for joining us this afternoon. Goodbye.
Thank you.